Hello and welcome. Thank you for joining us at our panel discussion on how to improve responses to freedom of information requests without resorting to litigation. I'm Grace Cheng. I'm Director of Practical Law Government Service at Thomson Reuters. Before Practical Law, I litigated FOIA cases at the U.S. Department of Homeland Security for more than 10 years. Suffice it to say, we saw some of the most contentious litigation in the entire federal government. But during the course of litigating these cases, I found many pitfalls that resulted in a huge expenditure of time on the part of the government with very little benefit to the requesters. While litigation has its place, our session will address ways to get what you want without a lawsuit. It's my great privilege to be moderating this panel of all-star experts, and I'd like to give them a brief introduction before turning the floor over to each of them in turn to give you more background on their vast experience in the field of public records. First, we have Colleen Murphy. Colleen is the Executive Director and General Counsel of the Connecticut Freedom of Information Commission. She's a nationally recognized expert on government transparency, information policy, electronic information issues, privacy, and data protection. Next, we have Michael Morisy. Michael is a former editor at the Boston Globe and a former John S. Knight Journalism Fellow at Stanford University. But most importantly, he's a fellow member of the NFOIC board and founder and chief executive of Muckrock. Michael Ravbitzky is a FOIA expert, attorney, editor, writer, independent researcher, and a prolific FOIA requester. Michael has a wealth of experience in requesting records from a wide variety of federal agencies and has been very successful at employing the strategies he's going to discuss with you today. Last, but certainly not least, Dr. James Holzer is the Deputy Chief Privacy Officer at the U.S. Department of Homeland Security, where he heads up the largest FOIA operation in the federal government. Dr. Holzer is a former head of the Office of Government Information Services at the National Archives and Records Administration. Our panelists are going to be offering a wealth of knowledge today about how to formulate requests, how to use what's already available publicly to better pinpoint the records you're really looking for, how to negotiate with FOIA offices, and how to improve communication to reach our goal, to obtain records as quickly as possible. We will have an open Q&A at the end of the session, so please feel free to drop any questions you may have into the Zoom chat link. I also understand there's a Whova chat link, and Erica will be helping us with that. With that, without further ado, I'm going to turn the Zoom over to our first speaker, Colleen Murphy. Oh, you're on mute, Colleen.
All right, kick it off that way. Perfect. Hi, everyone, and thanks, Grace. It's great to be with you virtually today for this NFOIC conference, and it's my privilege to speak to you about this topic that has really been my life's work. This particular topic, just so you know, I come at it from the perspective of an enforcement agency that oversees freedom of information disputes. And I am the Executive Director and General Counsel at the State Freedom of Information Commission in Connecticut. We're one of only 3 entities like ours, I think, throughout the country. There are some others throughout the world that are modeled a little bit like us. But our agency is an independent oversight agency charged with administering and enforcing the FOI Act. It was established way back in 1975, so has a rich 46, I guess, year history at this point. One of the big claims to fame that our act has is that it had unanimous passage back then in 1975. It established this commission, the commission for which I work right now, and developed a more comprehensive body of freedom of information, involving freedom of information, both with regard to records and meetings. I think our focus today is on records, but our law does cover both. We've got really broad jurisdiction over every entity in Connecticut, essentially, except for some creative quasi-public entities that are now coming on the horizon. But we cover everybody from, the governor all the way down to your tiny little sewer commission. And we also, which is somewhat unique, we cover the legislature and some components of the judicial branch as well. So we've got this great agency, not without not without some problems, of course, but very strong oversight body that actually hears complaints involving access disputes. So in our world in Connecticut, you don't have to go to court. In fact, you really can't go to court unless you come through the Freedom of Information Commission first. Many benefits to it. There's no fee to coming before the commission. You don't need a lawyer to come before the commission. You get to come and you get to require the agency who's withholding records to come before our commission. Again, it's an independent body. There's lots of procedural safeguards built into it, statutory safeguards to ensure that our agency doesn't answer to any one particular person, the governor, the attorney general, the secretary of the state. Lots of safeguards built into our law. But if you have an access dispute, you can come to the commission. We offer informal guidance. We resolve these disputes. They must be resolved within a year of filing, which in some ways seems long, in some ways doesn't seem so long, but we have to resolve everything within that 1 year time period. A big part of what we do, though, is mediation, and I think that kind of shapes the more substantive talk today about how to how to increase your success at access without having to resort to litigation. I will say too, in our state, only about 15 of our decisions that we issue are appealed, and they are otherwise binding on the agency. So I think we're pretty successful at what we do. And a lot of what we do, though, in advance of actually hearing and deciding cases is trying to resolve them through mediation. So I think the experience that our commission has gained through that process might be helpful to this discussion. Again, coming at it from the state level and from the experience of somebody who's tried to get people to talk and resolve short of our formal complaint process and litigation. So I've kind of encapsulated the discussion to make it nice and snappy for you into 6 C's, not the 7 C's. I came up one short. So we're at the 6 C's, but C's meaning that my little encapsules here all begin with the letter C, and they kind of formulate the phases of access requests, and each has like a little tip or two within it, and then a caveat. So the first one is clarity, and I think you're going to hear a number of our presenters talking about this, that the first phase of an access request is actually making that request. And I think that the biggest key is to aim for clarity. And there's a desire, I know, I talk to a lot of people who are looking for records to be as broad as possible. You don't want to miss anything, right? But I generally recommend steering away from that, because that provides an opportunity for agencies to say, oh, whoa, that was overbroad, that was unclear. We didn't know what you wanted the same thing with being vague. So don't be vague, be as clear as possible. Vagueness allows agencies to just, again, say, we didn't know what you meant, and just kind of set it aside. And if you don't know the actual names of documents, because of course the requesters aren't the keepers of the record, so they don't know that, the specific name of a document, but just common sense would dictate that you would just try to really describe what it is you want. If you don't know what the particular form is that particular agency uses to describe their water contamination inspection reports, then just say, I want the report that contains that information. Kind of simple stuff, but I think it's really important to be clear, not be overbroad. But I guess the caveat is sometimes you have to go broad. So that's the caveat. But second would be communication. So once you get your request in, communication, the second C, try to speak or otherwise correspond with the record keeper, the frontline staffer, the FOI liaison during the process. Might be tricky to do, especially in these increasing electronic times that we're dealing with. But you have to really try to establish a relationship. And that's always been the case back, I think, from the beginning of time with, I think folks in the media understand this, to establish a relationship with whoever you're dealing with, especially if it is an agency that you frequently deal with. I think that generally benefits you in future situations if you can kind of get a baseline relationship with the person. The caveat there would be, it might not be possible to do that at a larger agency or perhaps at the federal level. And I think others will talk about the federal level a little bit more than me. The third C would be compromise, if you can. Think about whether there is something you can cut back on in order to gain faster access without the time and expense of litigation. You might lose out on getting the entire pie, but you might win a very juicy slice of that pie, which can lead to a more incremental approach. If you kind of resolve to just get that piece of the pie, you could always go back and try to get some other pieces of the pie. It's something that some people don't really like to do, but I think if you can do it, it benefits or speeds things up for you too. The fourth one would be coalesce. I think if you follow those first three C's, you increase your chances of coming out to a place where you can coalesce, come together in a place where both sides feel at least okay with the situation. Neither one feels like they got something over on the other. The agency can feel like it did right by the requester and this is going to go away, and the requester feels like they got something out of it. The caveat here is this may never happen. You may never coalesce, but I think it's worth trying to get there. And then in the next phase, when you actually coalesce, is compliance. And this is, of course, the natural, place in the process where you want to get. The agency complies following that period of coalescence. But when you're in the realm of compliance, be sure to establish and understand, both sides understand what the timetable is for compliance, and have a clear understanding of what compliance means to both sides. Because sometimes that gets a little tricky too, where one side says, I thought you were giving me X and you gave me Y. So clarity with regard to the compliance as well. And that's, I guess, the caveat. If there is any lack of clarity in those first four steps, there might be problems achieving appropriate compliance. And then my last C is copacetic. Now everyone walks away happy. That's in the perfect world, right? The agency has one less FOI problem to tackle, and the requester can move up onto the next FOI hurdle elsewhere. But the requester can then write a story if that's what you're doing. Print the story. Talk about how you got access using the Freedom of Information laws, and just dig deeper into a particular story. So that's where copacetic comes in. Like, everyone should be happy. But the caveat, of course, is we don't always live in that perfect world. But I do think it's worth striving for. I've seen these elements of the 6 C's in operation, and generally people want to come to that place of coalescence. And I think that's led to good success at our commission. We do resolve something like 2/3 of all of our complaints through the mediation process. So anyhow, that's what I've got to offer, the 6 C's, and I'll let the others who are more in the trenches, I suppose, than I am, give you their take on it.
Great. That's such a great, oh, sorry.
Oh, thank you, Colleen. I'm gonna turn it right over to Michael.
Thank you so much, Colleen. If I had to add one more C, I think it would be commiserate when things don't end up copacetic. But I think that's really such a great kind of overview of kind of the different process, and just a good reminder that most agencies are trying to get to a place where we ask them, especially at the local level, we ask agencies to do so many things on behalf of the public, usually under very tight budgets and with minimal training, and kind of finding ways to kind of come together with them to work through this process. And Connecticut is such an amazing model a really great process, and hoping to see that end up in a few more states, especially if we can get more legislature subject to the freedom of information laws. I'm Michael Morisy. Again, I wanted to talk a little bit about sort of how do you actually kind of figure out what to request in the first place, right? Because I think so much of this happens, so much of the problems with the FOIA process happen before a requester actually submits the request, maybe because we're not clear about what to even ask for, or because the agency's record system is more of a garbage fire than we can even imagine. And that's usually not the public records officer's fault, but it's the reality. And so the first thing about if you want to file a request and avoid needing a lawyer is be careful about sort of emulating lawyers when you're actually crafting that request. I think one thing with social media, FOIA is really big on social media, which is awesome to see. And I think one thing we see a lot of times is sort of these big flowery public records and Freedom of Information Act requests filed by NGOs and lawyers and really great groups. And first of all, I'm very dependent on lawyers keeping me out of trouble that I get in. And I think it's a very important part of the process for public records. The caveat is that many of the lawyers I know who are fantastic when it comes to litigating FOIA requests are not great at actually drafting those initial requests. They start putting in a ton of legalese. They start kind of overwriting requests or kind of playing mind games with the agency before they've even submitted the request. And I see requesters who kind of mimic that language or kind of take a template they've seen from a national organization and start applying that to their request. And so the first thing I'm going to suggest is remember that there's a person on the other end of that line, that there's a person who's receiving that request. And just like if you get a long rambling email where you're not quite sure what the person is asking about versus something that's clear and concise and actionable, remember that that's going to go a lot further in terms of making it easy for them to help you. And so I think the first thing is kind of don't try to over lawyer requests, because a lot of times that'll take you to needing a lawyer, and trying to just remember that the goal of public records requests should be making sure that they understand what you're actually asking for and know how to search for it. I always advise folks to try to get specific when possible with requests. And there's a lot of caveats here. That could be a whole other panel. But some of the things that you might want to be looking for are sort of like, can you figure out what the name of the document is? Have you seen forms like this in the past? Who actually has that document? Federal agencies in particular are massive sprawling entities where if you've been following something in the news, you've been following something in your domain, the Freedom of Information Officer who gets your request, even at a local level or the state level, they might have no idea what you're talking about. And so making sure that you can kind of point them in the right direction on where to direct that request internally. Be like, oh, the mayor mentioned this at their press conference. So this was released as part of the, mentioned in a footnote on this document that your agency published. Little breadcrumbs like that go a long, long ways towards helping that person actually respond to your request. References that the document's made. Some of my favorite FOIA requests are when requesters have kind of like looked at little throwaway lines in a press conference or kind of like oddball mentions on a government agency's website. And that requester was like, hey, I wonder what that actually says. I'm going to request that underlying document. There's a group of really nerdy people who kind of follow White House Flickr accounts and look for sort of like keeping documents outside of a folder and then request that document because they can zoom in on the Flickr account and they now know the name of that file. So getting creative and bringing that to the process will go a long ways and actually help the agency kind of understand what you're asking for, because so much of the time, miscommunication or misidentification or just people kind of talking past each other really holds up the Freedom of Information Act processes and kind of really kind of puts requesters in a place where they feel like they have to sue. So when it comes to getting specific though, beyond kind of subscribing to your local government agency's Flickr account, what can you do to kind of figure out what you can actually ask for that's specific? One of the pieces of advice I always really like is trying to think like a middle manager, right? I think a lot of times as a journalist, if you come to the process as a journalist, you're thinking in questions and stories. If you're a citizen, you're kind of thinking about a core issue that you care about. But the truth is that government relies on sort of documentation and bureaucracy. I think bureaucracy's got a bad kind of taste a lot of times to it, but it's really important because it's how we make sure that these processes are consistently run. And so I think as you're thinking about what can I actually file a Freedom of Information Act request for, kind of take off your journalist hat, take off your sort of activist hat, take off sort of the questions you have and start thinking about the things that you care about as if you were actually in charge of that program, and start thinking about what are the documents that might actually exist that are going to answer the questions you have, right? And so every time the government spends any money, anytime there's a new program being initiated, they have to do training to kind of onboard the staff for that program, and start thinking through, like, what are the universe of documents that are likely to exist about the issues that I care about. And I found that's going to be a really effective way to kind of go from, I want any and all documents about topic X, which I'm sure folks will, like, when I talk with FOIA officers, that's the #1 complaint, is like, any and all documents about X is way too broad a request. Ask agencies to make judgment calls. They're not really sure what to do with those, versus a copy of training materials generated as this agency is rolling out this program. And that's a much more specific request, and it's something that the agency is going to have a hard time kind of denying exists. And so a lot of times that's going to be a more fruitful approach, is sort of thinking through, if I was in charge of this program, if I was in charge of this data gathering effort, what are the documents that would exist? And there's a lot of different ways to kind of get a sense, right? I think one of the challenges as a requester is, agencies a lot of times are a black box, right? We can't really peer inside them effectively. And so I think the first thing to do is just go check out the agency's website. Here behind me is a screenshot of the FBI's, they call it the Vault, a nice catchy name. Each federal agency is required to post commonly requested documents, but local agencies are increasingly posting a lot of sort of forms that they ask people to fill out. They're starting to post FOIA requests that they get. And just poking around an agency's website and just kind of, as a requester, kind of noticing, hey, are they asking people to submit some information? That means that information goes into a database. That's something you can request. Do they have sort of a list of sort of annual reports? Do they sort of say, hey, inspections are coming up for our hot dog stands around the city. Now you can know, oh, I can request hot dog stand inspections, and so on. And so just checking out a website and kind of checking out and just kind of looking for, where is evidence that there's documents that they haven't posted yet, or a database that they might be collecting. Now, government agencies' websites, they've come a long way. Still a lot of times not the best designed websites out there. So one trick I found really, really helpful is, and I apologize if you can't zoom in, but Googling, like putting in site : an agency's website, and then file type : PDF will kind of show you, kind of get Google to kind of just show you a lot of random PDFs that agency has posted. A lot of times agencies don't even realize everything that they're posting. They're not really sure how to navigate their website. And so if you just kind of see, like, what PDFs has this agency released in the past? What have they posted online in the past? There's a lot of really valuable information out there. One time we found out that the Marine Corps had accidentally posted its entire intranet publicly. And so being able to kind of use these kind of tools can be a really great insight for a requester, with the upside that if you find something useful, it came back to you in a fraction of a second as opposed to 6 months. One of the other things, it's coming towards winter. We're looking for some long, nice reads to kind of get cozy up eventually at some point when those winter evenings come. One thing I highly recommend is everybody get your state's records retention schedule. If you just Google PDF records retention schedule and then your state's name, there's usually going to be one or maybe a couple different sort of large documents that kind of detail all the different types of records different agencies need to keep and how long they need to keep them. That can be really, really helpful as a requester, because now you're sort of starting to see what is the actual language that a given agency uses when it refers to different types of documents. What are the different kinds of lengths of time that they actually have to keep those documents? Now, not everything in a records retention schedule is going to be subject to public records law, and not every records retention law is, if it's records retention law says they have to keep it for 3 years, maybe they actually keep it for 5. But that can be a really helpful kind of tool as a requester if you're like looking for disciplinary records, if you're looking for documents related to schools. Look through your state's records retention schedule, and it's a great source of inspiration. Plus, if the agency says, oh, we don't have those records, you can point to the records retention schedule and say, oh, actually, you're supposed to keep them for 3 years. So that can oftentimes get them to look a little bit harder when you kind of point out that if they don't have those documents, they're violating the law. One other, I'll get this up here. And then I do run a website called muckrock.com. We're a nonprofit. We've just helped file our 100,000th public records request. The vast majority of those requests are online and publicly available for other people to view and browse. I think when I started out as a requester, I was really kind of paralyzed in terms of what even to actually ask for and what kind of language to use. You've got about 70,000 public records requests that you can search through and explore. Feel free to copy that language. And you can also filter by what was actually a successful request. And so one of the things that I found a lot of times is just if somebody filed a really interesting records request 3-4 years ago, or if somebody filed a really powerful public records request in a different community, refiling that in my own community or refiling that for updated data can oftentimes be a really, really useful way to get access to really important information. If something's a scandal in one small town, I guarantee you it's going to be a scandal in other small towns as well, or big cities or federal agencies or anything else. And some of the things, as you're kind of looking through the sort of different documents, some of the things that you're going to be kind of looking for as kind of clues and breadcrumbs to kind of actually write your request are how can you keep that request clearly defined? And you can be really creative. I think one of the things that we often forget is that FOIA can be a really creative pursuit. It's kind of got for a while a bad rap as sort of a stodgy kind of field, but you can sort of think creatively about what is a document, what is a record. I want a copy of sort of inspection, copy of your agency's homepage intranet, for example. That's a really great suggestion I heard once. So kind of taking that creativity, taking what you've learned from other places, and kind of using each kind of find that you get, whether it's on a website or from a FOIA request that you get back, and kind of using that to kind of inform your future requests. And so again, keeping your requests clear, to the point, setting date parameters whenever it makes sense. A lot of times we see a lot of back and forth just saying, hey, a lot of these agencies have existed a long time, especially up here in New England. They love reminding us that they've been around for hundreds and hundreds of years. So do you actually want fireworks display documents going back to 1776? Probably not. So maybe just the last 5 years worth of these documents or something like that. And again, tips on how, who might actually have those documents. And you can leave that open-ended, but saying, I think this person might have an idea of where these documents will store. That can kind of go a long way. And then just be creative. I think one of the great things about public records is that persistence, creativity, and being willing to kind of negotiate and actually talk through with your counterparts in agency offices will go a long way. And one thing we found is that if you continue to kind of invest time and creativity, and also just remember that this is a very human process. This isn't automated. This is not Google, but there's people on both sides of these issues. It's something that can be incredibly rewarding and also incredibly important to our democracy. So with that, I'll hand it off.
Thanks, Michael. I'm going to turn it right over to our other Michael.
Hi, thank you very much for inviting me to the panel. I find that FOIA has always something new in it. Every situation is different. There's always interesting issues being raised, but that also means it's hard to explain a cookie cutter approach. And over the years, I've come to realize that establishing personal connections with the FOIA officers and working with them on a trust basis and trying to understand where they're coming from is really important. So I'm going to talk about 4 areas in my limited time. One is think like a poker player. Second, what are things to keep in mind when working with agency FOIA offices? Third, how can you effectively negotiate with FOIA offices on requests? And 4, how can you narrow a request without giving up the farm? So like poker, FOIA involves imperfect information and asymmetric information. By that, some people have more information than other participants. And just like any other game, you have to work with that framework. It's complicated sometimes. So you have to be willing to engage in horse trading and have the chance to give and take. And there is give and take. It's not a monolithic process where you put in a request and the machine spits out a reply and you accept that. Sometimes there's an opportunity even before the request is answered to talk with the FOIA officer that's actually handling it, put yourself in their shoes and so on. One thing that I find useful is to express a willingness in the request to narrow a request if express a willingness to revise a request if necessary, if it becomes difficult. I haven't used that as much as I should have, but I think it's a great idea for opening up that conversation from the very outset. Because you may ask for something, you're not sure what's there. The agency may say, oh no, this is going to be really impossible or difficult. Let's start that conversation. So express your willingness to narrow request if you're told what's available. A couple of agencies like the FBI even have negotiating teams, but most agencies are definitely willing to discuss a request if you reach out to them. There are certainly win-win outcomes available if you're willing to give and take, where the requester gets most of what they want, the agency avoids some impractical administrative burden. It's important to be cooperative and respectful when you're dealing with agencies, but go after the records aggressively as well. These are records that you have the right to ask for, and they have a right to explain to you why they can or cannot give them to you. Be willing to help the FOIA officer in their job. What portion of the records might be easier to retrieve and process? Ask them if there's things that are easier to get, and whether there's items in there that you're asking for that are much more difficult. Maybe if you hear the reasons behind that, you might be more willing to reconfigure request a little bit, not only to speed it up, but also to reduce the burden. I'll just add in here, sometimes FOIA officers give out information unwittingly or unintentionally. They disclose things through either a bad redaction, or they make a mistake and leave someone's name in where they shouldn't have. And in most cases, it's really important to bring that to the attention of the FOIA officer and be willing to swap out a release. That builds trust for the future. I think it's very important. That happens quite often, actually, and I do my best to try to bring that to the attention of the right people and let them know before they discover it and before it becomes a problem for anybody. That way we can fix it. Is there a data column that has lots of personal information in it that requires manual redaction? Maybe you don't need that column, and you can tell the agency, hey, this is a problem, but only because this one column has names and addresses and so on, or personal data. So there's ways of segregating out personal data by pulling out columns. Some requesters are more time sensitive than others. For example, journalists and commercial requesters, and they may have less negotiating space with regard to response time, but many requesters are not as concerned with the response time. They just want to get a good answer. So you can work with that and try to, explain to the agency you're not in a hurry, you're willing to wait. It's not, you're not on there breathing down their neck for the response and to do their best. Or you can say to them, I'd like to get a little faster. Can we drop these parts which are harder? And like in poker, be willing to fold on a hand and withdraw a request. Sometimes it's just better to drop it. If a request gets quote unquote complicated, it's easier just to withdraw it sometimes and start again and refile something more clear and more easy to respond to. You can always file a new request that's better formulated. And you should know the agency playbook: overbroad, vague, not a proper request, already a public record, but in an unhelpful form, not required to do research. These are all things that agencies can say in responses, and this is not the end all. Sometimes this is an invitation to start the conversation going. And grab the pot when it's there. If you go back later and try to get records that you got some of, they may not be there later. So it's important to, if you want all the records, go get them eventually, or rather soon, because they could disappear. They could be past their date by which the agency no longer is required to keep them. Secondly, what are things to keep in mind when working with agency FOIA offices? Every agency is different. Put yourself in the shoes of the FOIA staff members. Be attentive to the limited time of the FOIA office staff to understand and act on a request. Keep it simple and explain so it's clear and understandable. They get a lot of stuff. People send multi-page requests, as Mike Morisy mentioned. They don't want that. They want to know exactly what you're looking for. If you can point them to what office, what department, what website it's mentioned on, who's the author, if you have it, whatever pieces of information you have. It's like looking up the name of a person with a common name in the phone book. Unless you have the middle initial, unless you know what street they're on, it's going to be really hard to find. Don't ask for everything. Assume good faith unless you're shown otherwise. That's really important. And strive for reasonableness. Try not to make requests that would be burdensome because you don't know what requests are available. Instead, try to find out what records might be there. And that may mean talking to the FOIA public liaison before you even file a request and say to them, I'm thinking of filing a request for this kind of record. How do you think I should frame it so that it causes the least disruption? I find that telephone is better than emails or letters. Emails or letters can be sort of abrupt. And if you have all the people together on a conference call, well, that's a little difficult to arrange sometimes. That can clear up difficulties in a very short amount of time because people reach an understanding pretty quickly. I've found that it's good to enlist the FOIA officer in your request. If you can explain the goal of your request without causing a problem, that's helpful. And with COVID, it's been difficult for agencies to fill their vacancies. There may be more willingness to wheel and deal a bit to make the requests easier to process. Try to encourage a personal connection with the FOIA officers. Sometimes you can establish a long-running conversation with them to break the ice and make a good connection. Use a still interested letter. The still interested letters are where agencies come back to you and tell you, are you still interested in this request? Use that as an opportunity to open up a discussion. Yes, I'm still interested, but I'd be interested in discussing my request. So how can you effectively negotiate? Most people don't realize there's a lot of opportunities to negotiate a better outcome. Don't assume the FOIA office knows what branch or component has the records, but they do have a lot of power to decide which parts of the agency to send the request to. You can do, as Mike said, do some site-specific internet searches to see if there's anything already out there that will help them find the records. You can use federal yellow book, leadership libraries, organization charts, congressional budget justifications. Those are all things that are really useful, especially the org charts, most of which are online, so you can look them up and see who does what there. For large fees, find out why they're asking for large fees. What's contributing to that fee? Is there one thing that's causing the bulk of it? Can you reduce that somehow? Or is it even legitimate? Sometimes you get files that aren't legible. You can't see them. They're not very good quality, or they're in the wrong format, so you can't use them. And you can ask the question, is this a file with the quality that someone would give to their boss? And finally, if an agency withholds records, see if they've given out that type of record before. It's very, very common. An agency staff who hasn't been there that long perhaps decides that they shouldn't give out a record, but in the past they have given out pretty much the same record. So those precedents are important for their to help guide them in a good decision. And the last point is narrowing request. Change the discussion from what do you really want, which they may ask, which involves guesswork sometimes, to what records do you guys have? What kind of things can I ask for? Try to narrow as much as you can, but ask also, if it's a database, you can ask for the whole thing and not feel obligated to limit by date. Sometimes they ask for date limitations, but you can also limit emails. If you're asking for emails, you can limit them by date, by recipients or senders. You can limit to from, to, carbon copy, BCC, those kind of parameters. You can limit by keywords, but be careful of using too many ands between keywords because that can eliminate so many emails. There's not much left. You might forego attachments and enclosures. I find that those are useful to eliminate from the request because that way you can always go back and ask for them if you need them. But most of the time they're not very helpful and they cause a huge amount of processing because there's so many pages long. You can ask for just the outgoing emails. You can ask for the title page and the first 10 pages of each document, say. You can ask for the first 100 rows of data in a large spreadsheet to see if you even need it. That way it saves them a lot of time. Think creatively or just ask the FOIA office for their idea. Sometimes they'll offer an idea for narrowing it. You can ask for logs and lists and indexes, like a log of congressional correspondence with descriptions rather than the letters in their entirety. It's usually best to exclude compilations of news articles because those will often fall into a keyword search for email. And there's just lots and lots of news articles, and for the most part, nobody even wants those. And that takes a lot of time by the agency staff. Some agencies refuse to search for emails by keyword. And in those cases, litigation may be the only way to proceed because the agency has already made an executive decision not to process those kind of requests. And finally, in narrowing a request, especially for email, don't make the request too over-specific. I know you're supposed to make it specific, but with emails, you may eliminate things that you really need. And you're willing to look through the emails. Sometimes putting in a limitation by the subject may cause it to be such a small number of records that you really don't get much of what you want. So I look forward to hearing Dr. James Holzer's comments as well as the questions for the panel. Thank you very much.
Thanks, Michael.
All right, well, thank you. And first, I just want to thank Grace for inviting me to be on this panel, and then also the National Freedom of Information Coalition for putting this discussion on the agenda today. So my early days as a FOIA processor showed me the value of opening up lines of communication with requesters. That's a belief that I took with me, and that was reinforced as I became a supervisor and moved up in the ranks in the DHS FOIA office. And then, of course, when I moved over to become the director of the Office of Government Information Services, or OGIS. So providing requesters with a high level of customer service is a principle I continue to instill into our operations as the Deputy Chief FOIA Officer at DHS, and is something I continue to support and advance as a member of the DHS Privacy Office leadership. Of course, we still have work to do, but I'm proud of the advances that we've made over the last decade or so. Now, one of the reasons I've devoted many years to FOIA is because of my commitment to government transparency. Providing insight into agency operations is a public service that ultimately strengthens trust in government and improves our operations. I also saw an opportunity to use some of my skill sets to make the process work better. So at DHS, this has meant adopting modern business strategies to improve our services to the public. And in March 2020, as the Deputy Chief FOIA Officer, I published a 3-year strategy to accomplish this by upgrading our FOIA IT infrastructure, investing in our employees, and strengthening our regulatory and policy structure. Again, this is a work in progress, but DHS has made some impressive advances on that agenda over the last year or so. Now, I understand that me saying I have a 3-year plan to improve DHS FOIA is probably not very satisfying for people in this room, and maybe even with some folks on the panel who have had requests pending with us for 3 months or maybe even 3 years. So my goal for today is twofold. It's to help you understand how we operate and how you can get the help when needed. So one of the first things to address is, why does it take so long when the law very clearly states that we have 20 or 30 working days, depending on the circumstance, to reply to your request? So at DHS, we face 2 primary challenges that limit our ability to be as responsive as we would like: volume of requests and volume and complexity of records. So as you may know, DHS receives about half of all requests in the federal government each year. Now, it's important to understand, though, that the majority of those requests are first-party requests for immigration records. People need those records for a variety of personal and often time-sensitive and important reasons. They may be applying for citizenship or some other benefit, or even facing deportation. The kinds of redactions that we apply to those records are pretty standard, and we have a process in place to move through them pretty quickly. Now, when you receive the volume of requests that we do at DHS, the unforeseen circumstances can turn into major problems quickly. So for example, the Privacy Office, we handle a type of requests that allow us to search for information using fingerprint scan cards. Now, we've been working with the American Immigration Lawyers Association and others to get the word out that we can still run the search if the requester sends us a scanned copy of the request. We still receive lots of large envelopes from law firms each week. So during the time our staff was not able to come into the office due to the COVID-19 safety precautions, we received about 25,000 of these requests in the physical mail. Just this month, we have finally caught up on that work so that we are at what we would consider steady state operations. Now, requests that are not first-party requests for immigration records often face a very different volume problem. We generate an ever-growing number of records, and the volume of records we have on any given topic make it harder for us to locate the records that you're seeking, and it gives us more work to do before we can finish the page-by-page, line-by-line review of the records you want, and then we can send them to you. So technology can help address both our volume problems. And I'm particularly hopeful that the new FOIA processing solution most of DHS is moving to will help. So we started the search for a modernized FOIA processing solution by identifying the capabilities our components needed to do their work. And based on this work, our solution will give our processors access to advanced processing tools. And it includes key features that will decrease the administrative work associated with logging in and transferring requests and documents between components. But technology is not a silver bullet, and finding the right technology to do the job is only part of the answer. FOIA officers also need to have the processes in place to effectively manage operations. From an oversight perspective, this means having a structured reporting program that is looking at the right metrics and having empowered and capable supervisors. And from an employee support perspective, this means having a solid training and mentoring program, building career paths within your program, and recognizing good employees. So now that I've generally described some of the challenges we face in responding to requests, I want to talk a little bit more in detail about what happens to your request once it comes into the agency. I'll try to reflect on that process generally based on my experience with OJIS, and then I'll share some specifics about the DHS process. So once receipt of your request is logged in, the FOIA staff will evaluate your request to determine whether or not it's perfected. So generally, having a perfected request means the request has been sent to the correct office and the records are reasonably described. On intake, we should also be evaluating any requests for fee waivers or requests for expedited processing. Now, the law requires we respond to a request for expedited processing within 10 days. And if you're interested in a fee waiver or expedited processing, you should read the agency's regulations to see if you qualify. The next step in the process is our search. Now, we will ask offices that we believe are likely to have the records to conduct a search. And if you know the account or the office that you want to have searched, it's a good idea to put that in your request. If the topic of your request is very broad or your search terms are likely to turn up millions of unrelated records, we may require that you provide us with an office or an account name before we conduct the search. Now, once we have the records back from the search, we'll first review them for responsiveness, particularly if we're using keywords to conduct electronic searches like the ones we do for email. The search results will often include a great deal of extra material that's not related to the topic of the request. And it's not a good use of our resources to process records that are not of real interest to the requester. So once we have a solid set of responsive records, our analysts conduct the required page-by-page and line-by-line review to determine what can be released and what must be withheld. Now, at various points in the process, you have the right to challenge our decisions. You can challenge our decisions on a broad range of issues by filing an administrative appeal. For example, you can appeal our decision to administratively close your request, our denial of a request for special handling, the quality of our search, or the redactions that we've made. Now, there are also options for you to seek assistance and ask for additional information about how we're handling your request. Each agency has a FOIA Requester Service Center and a FOIA Public Liaison. At DHS, you can escalate to the DHS Privacy Office Public Liaison if you're having trouble reaching anyone at the component, or if you're not satisfied with their response. You can also seek assistance from OJIS, which provides mediation services for requesters and agencies. So while we're working on your request, you also have the right to ask for and receive estimated dates of completion. At DHS, if you've made your request through our portal, you can track the status and request updates. You can also call the Requester Service Center or the FOIA Public Liaison. You can ask the DHS FOIA Public Liaison or go to OJIS. Now, one thing that's important to note is that estimated dates of completion are just that, they're estimates. We're going to make a good faith effort to say when we'll be able to respond, but you should not think of an estimate as a deadline. The amount of time that it takes to respond to your request depends on a lot of factors, including the number of pages we locate, the complexity of the material, the size of the backlog, and the office's priorities. So, for example, a new court order deadline may mean that we have to move resources away from initial processing to litigation. Now, that's a relatively, just a brief overview of what happens inside the agency to respond to a request, and I know I'm running short on time. So I want to wrap up with one big takeaway though. Both at OJIS and at DHS, I saw the relationship between a requester and an agency break down because the requester took the agency's delay in responding or the denial of the request personally. Now, I can understand that reaction because for the requester, it is personal. You're asking for records from us that are important to you. But from an agency's perspective, who is submitting a request does not matter. We're going to take the same deliberative approach for each request that we process, regardless of who submitted it, whether it's from a reporter from the New York Times, a member from civil society, or an individual. They will all get the same response. So with that, I'll end my remarks here. I know Grace has some questions she would like to get to. And thanks again for everyone having me here today.
Thanks, James. So I had a couple of questions, and we've touched on a lot of these points actually. But I think one of the questions that is very helpful in formulating requests are, what are the best ways for requesters to see what's already publicly available before they file a request? And I think I'm going to ask Mike Morisy to speak to that first.
Yeah, not to toot our own horn, but Muckrock has a very large repository of requests that you can kind of browse by agency, keyword, which a lot of requesters, including myself as a requester, have found really helpful to kind of see what language has worked and what language hasn't worked in the past. We also run a service called Document Cloud that is a lot of newsrooms post their primary source documents too. And that's a really useful resource if you're just kind of looking for like, hey, what's a vetted document that I can browse? A few other resources I really like. A lot of agencies have really put a lot of work into building out FOIA portals. And so FOIA Online or agencies' own FOIA portals are really great places kind of to start with and kind of search through and sort of see what are some key topics that have been kind of posted before. If they haven't put out a really good FOIA portal or a reading room, another great resource is Government Addict, which has a lot of FOIA logs already on it for most federal agencies. And one thing that a lot of requesters do is request sort of the FOIA logs of a given agency. You can do this at the local level too, but if you're interested in a federal agency, look at their FOIA log and see, oh, this person requested this really interesting sounding document. I'm going to request a copy of any documents responsive to request 1, 2, 3, 4. And that can also give you access to some interesting information, but get it to you in a pretty short amount of time.
I would also add there's an enormous number of FOIA logs on the Black Vault website. And there are also a tremendous amount of government records on the National Archives website. They have a search engine that has hundreds of millions of records, and many of them they've scanned and put online. Obviously, it's only a tiny fraction of the whole. But I find in general, Google is very helpful. In an unexpected number of cases, Google can help you find the records that you're looking for or something very similar before you ever make a request, just through some searches and maybe even site-specific searches of that agency's website by the tool that Michael mentioned. So I think there's a lot of stuff already out there. Agency reading rooms are not always necessarily easy to search, but Google and other search engines can get in there and spider them, so they're available.
Hey, Grace, if I could just add to that, I will say that, I'm particularly proud of our website. It's come a long way over the years. We just did a refresh this past year, and I think we have a lot of good information about DHS there. I think one of the challenges that we do face, though, which some have noted, is that you're not able to necessarily search across the space. And so what you may see at headquarters, it will be different than what you'll see at CBP or CIS. And that's just a bug of the system.
Great. That's a lot of helpful information. Let me see. So we've talked a little bit about how to combat what I call any and all syndrome. What are some of your best tips about sort of increasing the trust factor, helping people to avoid using phrases that are going to get them sort of almost automatically dumped into that overbroad and vague category?
I would say one thing you can do, because the requester often doesn't know what's there unless they have some special knowledge of the area or the program, is for the requesters to do some homework, look at the agency reports, because the agencies often talk about what they're doing and they explain the scope of what they're doing in things like annual reports, congressional budget justifications, which they put out each year and ask Congress for money and explain why they need it. Those things are very helpful. The inspector generals often do assessments of agency programs and go into extraordinary detail about the programs, and even mention some of the records that they've accessed in their footnotes and bibliographies. So I think the requester can do the research. The requester can also go to the agency and say, look, I'm looking for some information on this subject. What type of record do you think I might ask for? They're not required to give them an answer, but maybe if the requester shows that they're willing to work with the agency to sort of focus the request from the very outset, that might be a helpful way to proceed.
So, one of the things that I liked hearing from the other panelists was kind of like putting yourself in the place of the processor and having process. I think that that's a really good spot to kind of start, because, in the old days when somebody would say they want any and all records, you're probably talking about boxes of records, right? Paper boxes coming in that you're going to process. Now, if somebody is going to say any and all records, you're talking about terabytes of information. So if you can imagine, somebody saying they want any and all records related to immigration at DHS, just the sheer volume of records that's going to return. And our processors are going to have to look at every single record. So it's actually in your interest to narrow the scope down and say immigration records related to enforcement in this, this specific area at this time frame. Because you're going to get a response quicker, right? So if you say, hey, I'm stuck, I want immigration, I want it for the last 10 years, we're going to process the billion of pages of records, but it's going to take that much longer for you to get any responsive records back.
Yeah, absolutely. I actually really appreciated some of the tips that our panelists gave, because I know James and I definitely saw in the course of litigation, there was one case in particular that comes to mind where it was a bit of an any and all situation, but news article compilations, probably 20,000 pages of that. And we were able to work out with the requester that we would search for a particular term, give the requester that page where the term showed up, and if they wanted to see more, they could let us know, and they literally were not interested in any of the other stuff. But it sort of illustrates the dangers that that come with sort of any and all very broad requests. You're going to get a ton of records come back from a search that aren't going to be useful to you as a requester. So it's important to kind of be aware of that kind of stuff going on in the background of these agencies. So we have a ton of questions, actually, and I'm just going to kind of throw them out there. One is, how detailed an explanation should be given to the requester when the request is getting delayed past the original estimated time? Maybe James could take that one.
Yeah, I was hoping somebody else was going to jump on that. I mean, to be candid, I think that we should be honest and transparent in what the delay is, right? And give as much information as we can. It's probably not going to be satisfactory, to the requester's satisfaction, especially when you're like, hey, this request has been delayed for over a year. And as I noted, we had over 25,000 requests that were just basically sitting there because we couldn't get people into the office, right? And they needed that. But I think having that, being candid, it goes a long way in building that trust relationship with the requester.
I think from a requester standpoint, it helps to know where you stand in line. If you go to the bank and you know where you're standing in line, you have a way of assessing, where you are. If you don't have that information, it's hard. So I would say at a minimum, the agency would tell you what processing queue you're in, how many requests are ahead of you, and approximately how long they expect it might take, even though that's an estimate.
Colleen, did you want to jump in?
I think my answer is just going to be just enough. Give it just enough information to, establish, as everybody has said, that level of trust, and make sure that the person feels like that their request is being attended to, and that you're not just shoving it aside. I think just any level of communication, most requesters appreciate that.
Yeah, absolutely. So we have a question here about where the term perfected came from.
I mentioned in the chat that probably, if anyone knows what it is, it's Harry Hammett, who's the editor of Access Reports, which is a newsletter on FOIA he's been publishing for 30 years. But it seems to me it's most likely it came from some court decision, and the DOJ has their FOIA handbook, and probably a search of that handbook in the right place would uncover what court decision may have first mentioned it. They may have gotten it from the lawyer's briefs from the Justice Department or something like that, but that's probably where it originated, and it spread from there.
Excellent answer. I think that sounds right to me also. It'd be interesting to track that case down though. So Colleen, I think this is a question for you. What influence does partisan politics play in denying state agency FOIA requests?
That's a really good question. I mean, I think you know, the reality is that it plays a lot. I mean, it plays a big role, I think, particularly locally. I think there's a lot of personality involved at the local level. And I guess just, you know, our role at the commission, again, is we really just try to diffuse that. Just like James said, you know, you're not going to distinguish the one requester from another. We do that at the commission. You just, you know, you don't look at the politics of it, and you try to just get people to get along and set that aside and realize that the law is the law, and regardless of who's playing the game.
Yeah, absolutely. That is really important to remember. I think we all get caught up in it. You know, as administrations change, you know, I think it's human nature to become anxious about whether your request is being treated fairly. But I think it's important to remember that in virtually every instance, FOIA officers, people who are processing FOIA are career employees. They are not, they do not come and go based on politics. So, you know, it is important to remember that, you know, their role is there to effectuate the law and the transparency scheme. So there's a question, I think, for James. How far has FOIA processing technology improved the process? It's a three-part question. And how far have component tech systems been integrated to DHS? And how far have tech solutions been proprietary in format?
Yeah, so, you know, I think the technology